This module provided a comprehensive understanding of the escrow process and its integral role in Arizona real estate transactions. It explored the statutory duties of escrow officers, the importance of neutrality, the function of escrow companies in managing closings, the disclosure requirements between real estate professionals and settlement service providers, and the distinction between escrow and title insurance companies. Together, these topics reinforce the principles of transparency, trust, and consumer protection that govern real estate transactions in Arizona. At its foundation, escrow is the neutral mechanism through which property ownership and funds are safely exchanged. Escrow officers, regulated under ARS, Paragraph 6, 841 at SEQ, act as impartial fiduciaries who hold and disperse funds and documents only according to written instructions from the buyer and seller. Their duties include safeguarding earnest money, coordinating payoff demands, verifying title conditions, calculating prorations, and ensuring that all contractual terms are met before closing. Escrow officers must adhere strictly to these instructions and maintain accurate records to ensure compliance and fairness. A major focus of the module was the concept of escrow neutrality, which requires escrow officers to act with complete impartiality toward all parties. They cannot favor one side or act on verbal requests that differ from written instructions. Neutrality also extends to conflict of interest disclosures. If an escrow officer or company has any financial or business relationship that could affect their impartiality, it must be disclosed in writing. Additionally, Arizona and federal law prohibit prohibited compensation. Escrow companies cannot offer or accept referral fees, gifts, or inducements for business, as doing so violates both ARS, Paragraph 6, 846, and the Real Estate Settlement Procedures Act, RESPA. Section 8. These restrictions ensure that clients receive unbiased service and maintain freedom of choice. Building on neutrality, the module detailed the role of the escrow company as the central coordinator of a real estate transaction. The escrow company collects and verifies funds, prepares the closing documents, ensures compliance with lender and title requirements, records the deed, and distributes funds to all parties once conditions are satisfied. Escrow companies are licensed and overseen by the Arizona Department of Financial Institutions, AZDFI, and must follow statutory and ethical standards that guarantee accuracy, transparency, and security. Their neutrality is key to ensuring the lawful and timely completion of a transaction. The module also highlighted the requirement for disclosure of relationships between real estate brokerages, licensees, and escrow companies. These disclosures are vital to consumer protection because they inform clients of any financial or ownership ties that could influence referrals. Both Arizona law and RESPA Section 8C-4 require written disclosure of affiliated business arrangements, and ABAs, ensuring that consumers know the nature of the relationship, typical service costs, and that they are free to choose their own escrow or title company. For example, if a brokerage owns or partners with an escrow division, it must disclose that affiliation to every client before services are rendered. This transparency prevents coercion and promotes fair competition among settlement service providers. Finally, the module distinguished between escrow companies and title insurance companies, clarifying their separate but complementary functions. Escrow companies facilitate the transaction by managing funds, documents, and compliance with contract terms. Their role ends once the transaction closes and funds are dispersed. Title insurance companies, on the other hand, investigate the property's ownership history and issue insurance policies that protect buyers and lenders against title defects, such as liens, errors, or undisclosed heirs. Title companies operate under ARS, Paragraph 20 and 1561 at SEQ, and are regulated by the Arizona Department of Insurance and Financial Institutions, DIFI. While escrow ensures a secure closing process, Title insurance provides ongoing legal protection against issues that might arise after the sale. Understanding the distinction between these entities helps licensees explain the process to clients and ensure proper compliance with disclosure and fiduciary standards. Arizona case law, such as Burcons vs. Ticor, Title Insurance Commerce of California, 1991, reaffirmed that escrow officers serve as fiduciaries, bound by honesty and impartiality, while title insurers carry contractual liability for ownership risks. Key takeaways. Escrow officers are fiduciaries responsible for handling funds and documents according to written instructions. Regulated under ARS, Paragraph 6, 841 at SEQ. Escrow neutrality requires officers to act impartially, avoid conflicts of interest, and disclose any potential financial relationships. Prohibited compensation laws prevent kickbacks or referral fees that might influence client decisions. Ensuring ethical business practices. Escrow companies coordinate every step of the closing process, from earnest money collection to recording and disbursement of funds. Brokers and licensees must disclose any business or ownership relationships with escrow companies to maintain transparency and consumer trust. Escrow companies manage the transaction process, while title insurance companies investigate ownership and insure against title defects, each serving a distinct, legally defined purpose. This module underscored that escrow is more than an administrative step. It is the safeguard of fairness and legality in every Arizona real estate transaction. When escrow and title professionals act with transparency, integrity, and neutrality, they uphold the public trust and protect the rights of all parties involved in the purchase and sale of property.